Good afternoon. My name is Amy Stepanovich, and I'm the Executive Director of the Silicon Flatirons Center for Law, Technology, and Entrepreneurship at Colorado Law School. Today I was grateful to be joined by Reid, the Director of the Silicon Flatirons Telecommunications and Platforms Initiative, as well as Kaye, the United Nations Special Rapporteur on the promotion and protection of the rights to freedom of opinion and expression, as they discuss the now signed executive order from the White House on social media and speech on the internet. I was so grateful to be able to have this conversation, and I hope it provides a basis for people to understand what promoted the executive order, what's in it, and what comes next.
Can you set the stage for what's the dispute between President Trump and Twitter and the social media companies? What got us here? And then maybe we can get into the mechanics of what the executive order is all about and what the implications are.
So, I actually think that, if we think of it as a dispute, we might be giving this situation a little bit more credibility than it deserves. I mean, my view is, what set this off, basically, I think, as everybody knows and as seen in the press, is that, President Trump tweeted some information, some disinformation about mail-in ballots and the potential for fraud. I mean, his assertion is that they're fraudulent mail-in ballots, and the tweet was underneath it was affixed with a link that Twitter imposed on it that said basically, for the facts, go here. And that led you to a moment on Twitter that was essentially a fact check. So at root, what we're talking about is Twitter fact-checking the President of the United States. And this is pretty interesting and new because for the life of the platforms, and especially as a result of a policy last year, Twitter said, look, we have our rules, and we may apply them to everybody, but there's also a public interest exception, essentially, a public interest in people seeing and knowing what world leaders are saying. So even though particular content like, say, disinformation around the pandemic, it might not be consistent with their rules. In other words, Twitter might take it down or do something with that content to maybe slow down its amplification or something like that. They've said, well, we're not going to do that necessarily because of the public interest in knowing what leaders are saying. And so, Twitter actually took down a couple of tweets from the presidents of Brazil and Venezuela when they were posting disinformation about the coronavirus, but they'd never done that to Trump. And this was the first time they did that.
So for whatever the combination of reasons, we have Twitter intervene in this case and post these fact checks. Okay, so how does the president respond? And maybe put it in the context, this is not the first time that the president has engaged on Twitter with Twitter or in other mediums outside of Twitter with Twitter and other social media platforms. What does he have to say, and how does it escalate?
Yeah, I mean, he basically says, this fact check is a form of censorship. Twitter, by fact checking me, is interfering with my freedom of speech.
Let's unpack this notion of free speech a little bit more, because there are some different players here that occupy different parts of this story and maybe have different free speech interests. So let's talk first about the president. So when the president speaks in his capacity as president, does he have a right to free speech? Or what is that? Is that even a meaningful construct? Or try and unpack that for us a little bit.
Yeah, I mean, as a citizen of the United States, he certainly has the same protections that any of the three of us have against government interference with our free speech. I mean, First Amendment says Congress shall make no law abridging freedom of speech or the press. That it doesn't say there's an exception, and there's no case law that suggests there's an exception for presidential speech.
Let's flip gears and talk about Twitter here. Is Twitter obliged to let him say what he wants on their platform?
No, I mean, Kate Klonick put this really nicely in a very succinct tweet yesterday. I mean, we should, if we're going to be talking about Twitter, everything, all of our references should be to tweets. I think we should stipulate that. But basically, she said that the First Amendment protects protects Twitter from Trump, but it doesn't work the other way around. In other words, Twitter is a private actor. The First Amendment, and we'll get to the statutory protections here as well in a second, but just in terms of the First Amendment protects individuals against state action, right? It protects individuals against the government censoring speech or putting restrictions on speech that do not meet basic standards of legal scrutiny. But that doesn't apply to Twitter because Twitter is just, simply not a state actor. And so those normal rules that apply to the state simply do not apply to a private company or to the private platforms. In fact, the opposite is true. And part of this is because of Citizens United, which is something that the right has cherished. But under Citizens United, there's an understanding that corporations have rights. Corporations have rights that flow from the Bill of Rights, our Bill of Rights, and that includes the right of freedom of expression. And so Twitter and Facebook and YouTube and the other platforms, they certainly have a right as guaranteed by the Constitution to design their platform as they see fit. That is a function of their First Amendment rights. Now, it's a separate question, which I think we'll get to, as to whether they should be liable for the content that individuals post on the platform. But certainly as a matter of, as an actor, they're not state actors, and they are protected by the First Amendment.
You mentioned that there's also a statute here. All right, I promised Amy we would try not to go too deeply into the weeds, but the words Section 230 are trending on Twitter right now. What is Section 230 all about, and how does that play into augment, supplement the First Amendment here?
Yeah. When you see Section 230 trending, you know something is wrong with the universe.
Maybe really quick before you move on to 230, it's worth saying what happened before Section 230, which is this so-called moderator's dilemma, right? And the idea with the moderator's dilemma is if a company takes action to moderate certain content on its site, or at least one court in the Stratton Oakmont case says, you are liable for everything else that happens on the platform. So if you miss something, if someone posts some defamatory content to the platform, you are therefore liable. And so we get this dilemma that is, your incentives are either to moderate everything so that you're very careful and you sort of over moderate, or you moderate nothing at all so that you can say, our hands are off. We don't have any control over what people post on our platform. And that kind of brings us to 30.
That's exactly right. I mean, you said it better than I could have. Section 230 deals with the moderator's dilemma on two fronts, right? It both allows for, in a way that I think is really important that people really need to understand, it not only allows for, but it encourages content moderation. It encourages the companies to adopt rules about what's legitimate and what's not on their platforms. And at the same time, it protects them against the liability on the first score that you're describing, because it says to the companies, look, if you do moderate, we don't want you to essentially serve as a gateway that forces you to over moderate. In other words, to deal with content in a way that kind of creates a censoring environment. We don't want you to be doing that, but we also want you to be free to develop the kind of platform that you want to create. So, I mean, at the very base level, if you want to create a platform for dog lovers and you want to exclude, because I think the three of us are all dog lovers, so I'm speaking to my audience here. You know, if you want to exclude content about cats, that's your prerogative. I mean, that's a kind of silly way of thinking about it. But
did you just say prerogative? Sorry, go on.
Ooh, ouch. Yes. So if we're going to go down the pun route, clearly dad joke zone. You know, I do think that that's what Section 230 is designed to do. I mean, we're not getting into the weeds of it, except to say that Section 230, in a pretty concise manner, is trying to create space for the companies to actually moderate, you know, to create in a certain way to implement their First Amendment rights without the fear of liability that might come from taking those kinds of steps and creating an environment that that could result in content that is, as you say, defamatory or something. Like, those individuals should be responsible for their content. It's not that the platforms themselves should be.
Before we return to the executive order, just one last thing to say about 230, which is often 230 is credited with the proliferation of platforms like Twitter, like Facebook, like Google. Why is that? Why do people talk about, there's one section of 230 that's often credited as the 26 words that created the internet, as Jeff Kosseff talks about in his book. Why is that? Why is Section 230 regarded as so important?
Well, I think in some ways it goes back to your moderator's dilemma, right? I mean, because what Section 230 does is, and this is how the platforms really developed. It allowed the platforms, I think, to create a zone for expression, for communication, without that fear of liability. I mean, it seems to me like that's the fundamental point about Section 230. It created space for the platforms to develop, and to develop without this kind of overhanging cost that would be imposed by constantly monitoring the content on the platform. So I think in the very early days of the platforms, when, you know, the content was, you know, in the tens of thousands or hundreds of thousands, it might have been possible theoretically to say, well, platforms, you should monitor what's going on. That's completely impossible when you're at scale. I mean, it has become, and we wouldn't want that. You know, we wouldn't want, I don't think, the platforms to be constantly monitoring all of the communication, all of the discussions that are taking place online.
You know, we talked about the good things behind 230. Blake talked about how it created the internet, which is, of course, the title of Koseff's book, as he referenced. But it has allowed a lot of bad speech to come online as well. And so just to provide that other side, not only does it provide space to moderate, but it allows harassment on major platforms that we've seen proliferate, not only by individuals, but be able to amplify. So one message could become 5, 10, 100,000 messages. And then they also are able to promote what content is seen or unseen. So in not only in regard to what gets taken offline or what gets put online, but maybe the order of messages that people see or things that they may never see from certain people. So there are things that people have genuine complaints with about 230. I was wondering if we could talk a little bit about the reasons why 230 might be under scrutiny right now.
So I totally agree with that. I think this is really important that, you know, we could think about Section 230 in all of its positive aspects, but in a way, because of its blanket immunity, you know, it took a long time for the platforms to get to, and maybe it was because of public protest and and kind of disgust with a lot of what was happening on the platforms. But I think, Amy, you're absolutely right. 230 isn't all of this. It's not just this rosy kind of a view of the growth of the internet within the context of the expansion of access to information and communication and all of that, and the ability to see my dog online, have a following and all that. It also absolutely created the space for abuse, for harassment, for misogyny, for doxing, for all sorts of things that were taking place. And the companies could, like, with a pretty high degree of security, at least early on, feel that they didn't have to moderate that stuff. And I think the debate so we should be having a debate about how best to regulate the companies. I mean, to my mind, there's no question we should be having that kind of debate. It's a debate that people around the world are already having. I mean, I was on at an event. I was at an event this morning on the Digital Services Act, the new regulatory framework that is starting to be considered in the European Commission, in the EU. So, like, that discussion is happening, and I think what this executive order shouldn't, and unfortunately I think it will, but it shouldn't really, in principle at least, distract us from the fact that there is a regulatory environment out there that we should consider. At least there's a regulatory framework in principle that we could be considering. It's not the one that Trump or his executive order are about, because what Trump's executive order, and we've talked about this before, and I tweeted about it, the order, it's not about changing the regulatory environment for social media, at least in my view. I think it's really, in part, that's because of the time frame that will be involved, the lack of certainty that any of this, or at least some of the key parts of this executive order, are even constitutional. But I think it's about Trump intimidating, and the Republican Party to a large extent, intimidating the platforms not to exercise the rights that they have, either through the First Amendment or because of the immunities under Section 230, to frame their space, to apply their rules. I think it's a tactic of intimidation and dominance, rather than a legitimate and, let's say, mature discussion about how social media should be regulated.
What are the details of the order and what it requires? You've kind of talked about time frame and about what the long run might happen, but what are we looking at that is going to come out of this? Both Blake and David, if you can contribute, because right now we have a draft and it might be being signed as we're talking right now. So imminently, we're going to see an official copy.
Yeah.
Well, I'll take the first run at it. So the idea here is, because we've got practices by Twitter around Trump's tweets that arguably implicate both of these issues that we're talking about here, right? On the one hand, bad content by Trump, and overbearing, fact checking or censorship as Trump conceives of it. So we've got sort of accusations of a platform doing not enough moderation, doing too much moderation, and they are doing allegedly too much moderation from someone who has the authority to issue an executive order, the president. And so we get this executive order, and we should emphasize as a draft. We haven't seen the final version, so it could change before it comes out. But the idea is to go after, at least mechanically, the 230 protections that are afforded to Twitter and other platforms. And it does that in a few different ways. Maybe the most important way is that it orders a component of the White House called the NTIA, the National Telecommunications and Information Administration, to petition the Federal Communications Commission, the FCC, to do a rulemaking to interpret Section 230 and basically to define out of Section 230 any platform that is engaged in political discrimination of some sort. And so the idea is, we're going to order the FCC to go in and tinker with Section 230, which some people aren't aware is actually part of the Communications Act, which the FCC is charged with administering, to go in and sort of tinker with 230 and basically try to find something in Section 230 that allows them to kick Twitter out for what it's doing, and then by extension cause some sort of ruinous harm to Twitter's ability to run its platform the way it wants to, or to shape up and stop messing with the president in his tweets. David, did I more or less get those mechanics right?
Yeah, I think that sounds right. I mean, I think none of us have had the time that, we as law professors, lawyers, might want to study a document as important as this one. But I think, you've totally covered the right elements from my perspective. Although there's also, I think Daphne Keller described some other elements as atmospheric, right? And I think these, the atmospheric material, I mean, there's some that are direct, and then there's some atmospheric. I think those are important as well. I mean, there is an element, I forget what the trigger is, but there is also an element that would basically say to federal agencies that if a platform is failing to meet the standards in this new interpretation, that they cannot advertise on the platforms. And that's an element that, from my perspective, I've seen all over the world as a tool that's used by governments to harass media outlets. Because in many parts of the world, the media depend upon government advertising, and that it's not propaganda. It's basic advertising about public auctions and so forth. And governments often use that tool as a way to harass the media and to make sure the media only covers them in an appropriate way, whatever that is. But there's other atmospheric elements in it too. There's a very lengthy attack on the platform's so-called relationship with China. And I think that fits into the kind of China bashing that we've seen around the coronavirus and that we've seen around China policy over the last couple of months as well. There's some other atmospherics, I think, that also just feed into the notion that this is as much a political document as it is a document that is really designed to change the government's interpretation of Section 230 and its use of those immunities, or failure to use those immunities when it comes to evaluating the companies themselves or regulating the companies.
Rebecca Tushnet this morning said that the end game of this executive order has already been reached, which is that this sort of intimidation that you're describing is already being realized, right? Twitter is already going to be spending the day to day thinking about whether they can continue the policy that they tried to enforce with the voting fact check stuff, whether they're going to be able to do that again, or whether they're going to have to sort of back away and say, we can't afford to continue this fight for another 6 months until the election and risk the president coming after us.
Yeah, and if I could just say on that point, a lot of us have particular views about the platforms, positive, negative. Regardless, I think actually now is a moment. I mean, it sounds ridiculous. These are, highly capitalized companies, but I think we need to stand with them in a way. And I would say that for two reasons. One is because, if Trump succeeds, just in terms of the US market, I think that's a huge problem. If he intimidates Twitter, so Twitter decides this isn't really worth it for our platform, that's really troubling from both the use of executive power and from our ability to use these platforms as a place to criticize government, to engage, and also to get accurate information in the face of a disinforming president. But there's another element too, which is if Trump succeeds and Twitter in some way caves to the president, whatever that looks like, that is a really nice signal to authoritarians around the world, which is, well, hey, Trump did it. Why don't we find ways to put pressure on the companies ourselves? And, honestly, Twitter isn't quite as important as the other platforms, especially YouTube and Facebook around the world. But they should all be watching that. They should all be watching that. You think the pressure from governments has been bad now, or up till now. It's going to get much, much worse if Twitter just rolls over and says, okay, we will, we're out of this public interest fact-checking game.
We're wrapping up. I'd love to have you look into your crystal balls that I know you both have sitting in front of you on your desks and say, after this gets signed, what is the next week, the next month of response look like? We have a few different government agencies who are implicated by the direct text, at least one major company that was involved in instigating the issuance of the order, but several platforms who are going to be impacted by it. What do we see coming once it's actually signed and official? And
I just looked. It is now, according to the Washington Post, signed and official. David, you want to take the first cut at the prognostication?
Yeah, I mean, it's a little bit hard to know. It's hard to know if one of the mechanisms is this really inane reporting scheme that was developed by the White House a year or two ago for the reporting of political bias. If that becomes, you could conceivably, it could become a conduit for reporting to one of the agencies. That could happen in the near future. We could see, there's this call for rulemaking. We could see that being triggered. Those kinds of, the mechanisms of government don't work nearly as fast as a Trump executive order does. So there will be some time, and we'll see how that develops. I think we'll see members of the FCC comment on this. Certainly the Democratic appointees are likely to be very critical of it. So there'll be some battling there. There should be some.
And they were today, both of them.
They were. So, there should be some public comment period. Well, it'll be interesting to see how that develops. I think from our perspective as both, scholars and advocates, we'll have to engage in all of that. It's unfortunate to a certain extent because I think it'll suck a lot of the oxygen out of, to the extent there was oxygen in, mature discussions around these issues in Washington, it'll suck the oxygen out of that. It will also, I think, turn people towards a more protective mode of the companies. This might, over the long term, this might serve as a way for people to think, well, maybe the companies do need some protection against government authorities in the United States. That might be some form of silver lining, and all of these things I think will develop over the coming weeks.
Well, and to the last point you raised, David, there are a number of fairly serious conversations going on about competition and antitrust law, about privacy, about cybersecurity, about accessibility and public safety and national security and so on and so forth, that and copyright, the Section 512 report that the Copyright Office released this week has a lot to say about what the platforms are doing. And I agree with you, and I think Julie Cohen and others were making this point this morning, that many of those conversations are likely to be derailed. I likewise agree on the points you raised about there's going to be a lot of palace intrigue about the implementation of this order, so that the mechanics are pretty novel in terms of all of the things that must happen before we would get to a court saying, come on, guys, this is unconstitutional, which include, there has to be a senior staffer at the NTIA who's got to put their name on a petition for rulemaking that urges the FCC to go along with this. You've got to have 3 FCC commissioners willing to vote out, a notice of proposed rulemaking and put their name on it and say, we need to dig into discrimination by platforms. By the way, just a couple of weeks after they rejected a similar call to investigate political discrimination by broadcast television stations, right in the middle of rejecting a call for investigating discrimination by internet service providers in the ongoing net neutrality dispute, which we talk a lot about here at Flatirons. So I think it will be interesting to see how this sort of filters through all of those pieces of machinery. And I think there could be a lot of side effects for telecommunications law, for how the Federal Trade Commission works, for the ongoing questions about how the Department of Justice works. But notwithstanding that your admonition to keep our focus at a high level, I think there are going to be a lot of little aftershocks and little sort of side battles that play out that may end up having impacts in other places.
Yeah, no, I agree with that. I think that we're going to be juggling a lot, and that I think it'll be really important for commentators and for those with influence or with contacts, connections in the media, to make sure that the story of what this is about is constantly told. Both at that micro level, but also I think at the higher level of what the purpose of this is all about.
Thank you both so much for taking some time with us. I really appreciated this walkthrough. I think other people will as well. Being able to sort through the vines of some of these conversations is sometimes hard to see the light on the other side, and this has been really useful. Have a great day. Thank you so much, and good luck getting through the now official order and wading through it.
Yeah. Thanks, Amy. Thanks, Blake. This was a lot of fun.
Thanks, Amy. Thanks, David. Be well.